Hey, you guys. So we are going to get right into it because thanks to Gina, that is Gina, Gena. Everyone, if you're entering the chat or if you're watching this on replay and you're in the comments, say thank you to Gina because she's the one that said Brian Steele has filed the motion to disqualify and recuse Judge Glanville from all further dealings in the above referenced Young Thug trial. So we're going to read through it. It's going to be a good time. I am so grateful for all of the comments and insights you guys have given me in the last week, but because this is 27 pages long, we are going to get right into it, and we'll catch up with some comments at the end. Let me make this full screen and let's go. And embiggen is the word, right? So let me know if that's better for you guys to read. You can see that it was filed at 4:59 p.m. Eastern. That was not too long ago, just over an hour ago now. So we're going to read this full heading here. Motion to disqualify, recuse Judge Glanville from all further dealings in the above referenced case, and motion for mistrial, which was goaded by the improper conduct committed in concert by the court and prosecution. Guys, it's already starting off with a bang. Comes now, Jeffrey Williams, by and through undersigned counsel, and hereby files this motion to disqualify and motion for mistrial, which we just read. In support of this motion, Mr. Williams, Young Thug, shows as follows. Undersigned counsel represents Mr. Jeffrey Williams in the above referenced case. The jury trial of multiple accused persons commenced on January 4th, 2023, before Fulton County Superior Court Judge Glanville. The trial is expected to last, at least, right? At least is a good term to put there, through the end of the 2024 calendar year. This is very optimistic if you ask me. On Monday, June 10th, 2024, within 5 days of the filing of this timely motion, this court, along with the prosecutors, engaged in an unlawful, improper ex parte meeting with, among other persons, a sworn witness, Kenneth Copeland, for whom an order of use immunity had been issued on Friday, June 7th, 2024. Now let's pause here. Guys, use immunity, he's safe from state prosecution, but that doesn't protect him from federal prosecution, which is an important distinction. And also, an ex parte meeting, the arguments that they're going to argue here, it would have been improper even if Kenneth Copeland wasn't sworn in, because it wasn't disclosed to the defense. There was possible Brady material that was shared, substantive material that wasn't disclosed to the defense. You know, there would have been issues here being raised either way. But the fact that he was also sworn in, and he's in this chambers having this meeting, that's kind of risky. That's kind of a crappy move for Kenneth Copeland, because what he's saying in these chambers, he's saying while he's actively under oath. So, two interesting things to point out in that sentence, but we're going to speed through. No notice of this ex parte meeting was provided to any attorney for any of the criminally accused in the case. In fact, the accused and their counsel were in the dark that this, quote, star chamber meeting occurred. Mr. Copeland had previously been called to testify on Friday, June 7th, asserted his Fifth Amendment privilege in open court in front of the jury, and was held in contempt and summarily incarcerated until such time he agreed to testify pursuant to the grant of use immunity. Judge Glanville and the prosecutors essentially admitted, by silence and by statements in open court, that an ex parte meeting occurred on the morning of June 10th, 2024, only after undersigned counsel revealed, based upon information and belief, that this impermissible meeting occurred. Now, put a 1 in the chat if you think that the silence and the way the judge responded to Brian Steele's initial argument about this ex parte meeting kind of was an admission that it took place. Put a 2 if you think it wasn't so much an admission. At the earliest opportunity on the afternoon of June 10th, the court was informed, based upon information and belief, the ex parte meeting with the sworn witness Kenneth Copeland and the prosecution occurred earlier that day, that the witness had made factual admissions, and that the statements were made to the witness by the court and the prosecutors acting in concert. Together. They're acting together. This is a heavy statement. This should not be overlooked, what's being asserted here. That the court and the prosecution are working together. And that's not the way things are supposed to be. About the amount of time Mr. Copeland could be held in custody on the contempt. The court denied undersigned counsel's request for the transcript of the ex parte meeting and denied the timely motion for mistrial based upon this improper and illegal ex parte meeting. So guys, I think every time we hear this ex parte characterized, it's no longer improper, according to the defense counsel, Brian Steele. He's going all in and saying it was flat out illegal. This illegal ex parte meeting, which violated Mr. Williams' constitutional and statutory rights, including the right to due process, fair trial, a fair tribunal, ethical prosecutors, and the right to be present at every critical stage of the proceedings under Georgia Constitution. A lot going on there. And then they're noting here that a transcript of the relevant proceedings from Monday for those arguments, as well as the ex parte, was ordered on June 10th. And he's noting that, once again, we can go to YouTube and watch the oral arguments that took place in the courtroom after that ex parte meeting. Now, Rule 4.1 and Georgia Code of Judicial Conduct 2.9 delineate rules governing ex parte communications. Now, what's funny is so many of you guys came into the comments over the last week and you're like, look, we can look up these rules. Why didn't the judge know how these rules worked? And you guys make of that what you will. Uniform Superior Court Rule 4.1 generally prohibits ex parte communications, except as authorized by law or by rule. Judges shall neither initiate nor consider ex parte communications by interested parties or their attorneys concerning a pending or impending proceeding. Ex parte hearings are only authorized in the case of extraordinary matters such as temporary restraining orders and temporary injunctions. In other judicial hearings, both parties should be notified of the hearing with an opportunity of attending and voicing any objection that may be properly registered. So, these were, I did it myself, you can Google, you put like the word Georgia, you put some keywords like ex parte, code, statute, you can pull it right up. So Brian Steele, he has to lay this stuff out to make the argument, but it was really interesting watching last week. Judge Glanville seemed to stumble over these rules when he was going back and forth with Brian Steele. I'm going to get a drink of water quick. Oh, you guys, so happy to see you guys here. We have Carol. We have Moo, maybe Mau Mau. Drea, so good to see you, Drea. Robert, Susan. And I don't want to keep going. I don't want to drag us down. Lemon apple pie, that sounds great. Roberta, Lori. Happy you guys are all in here and all chatting. So we've got some more parts of this Rule 2.9 here, this other rule. Judges shall accord to every person who has a legal interest in a proceeding, or that person's lawyer, the right to be heard. Judges shall not initiate, permit, or consider ex parte communications, or consider other communications made to them outside the presence of the parties or their lawyers concerning a pending proceeding or impending matter, subject to the following exceptions. So everything outlined here would possibly be an exception. Where circumstances require, ex parte communications are authorized for scheduling, administrative purposes, or emergencies that do not deal with substantive matters or issues on the merits, provided also that the judge reasonably believes that no party will gain a procedural, substantive, or tactical advantage as a result of the ex parte communication. Do you guys think that a party gained an advantage from this ex parte meeting? What do you guys think? Yes to advantage or no to advantage? And then B, the judge makes provision promptly to notify all other parties of the substance of the ex parte communication and gives the parties an opportunity to respond. 2, judges may obtain the advice of a disinterested expert on the law applicable to a proceeding before the court if they give notice to the parties of the person consulted and the substance of the advice and afford the parties reasonable opportunity to respond. Judges may consult with court staff and court officials whose functions are to aid in carrying out adjudicative responsibilities or with other judges, provided the judge, now this is important too, provided the judge may consult with staff and court officials, provided that the judge makes reasonable efforts to avoid receiving factual information that is not part of the record and does not abrogate the responsibility personally to decide the matter. Now, it's being alleged that some really important factual information that was not on the record so far came out during this ex parte meeting. Namely, that Woody, Kenneth Copeland, says during this ex parte meeting, he was the one that killed Nutt, or Donovan Thomas. That's new factual information. So, doesn't really seem like the judge avoided coming across factual information And then dealing with the record, we have this pushback where the attorneys are trying to get access to the transcripts from this meeting, and it's being denied. It's being denied. So, little interesting part there. 4, judges may, with the consent of the parties, confer separately with the parties or their lawyers in an effort to mediate or settle impending proceedings. Judges may initiate, permit, or consider ex parte communications when authorized by law to do so, such as when issuing temporary protective orders, arrest warrants, or search warrants, or when serving on therapeutic, problem-solving, or accountability courts, including drug courts, mental health courts, and veterans court. So that's not really applicable in the context. The court violated Rule 4.1 and 2.9. The court joined the prosecutor's team and is biased against Mr. Williams and favorable to the prosecutors as objectively demonstrated on June 10th, as well as throughout the pendency of this case. So to me, this is Brian Steele saying, you've crossed the line already, but you went way far and beyond on June 10th with what you did with this ex parte meeting. The trial court rejected undersigned counsel's substantive request for information about the unlawful ex parte meeting, and the court denied undersigned counsel's motion for mistrial. Instead, the court stunningly demanded to know how undersigned counsel came into possession of the information about the meeting. The prosecutor stunningly sat mute and permitted the injustice to occur, and for the court to attempt to intimidate undersigned counsel, meaning Brian Steele. Later, Love, a lawyer currently employed with the Fulton County District Attorney's Office, argued that the ex parte hearing with witness Copeland was ethical, just, and proper. The other prosecutor still remained mute. And I think when we were going through this live, guys, everyone was pointing out, we have ADA Hilton's been the one questioning Woody this past week. Chief Deputy District Attorney Love, she's the one with the short haircut. She wasn't in court today. She wasn't present. But you guys were all pointing out that the male that was sitting at the table with them while all this was going on, he was just sitting there completely silent with his head down the whole time. So you guys definitely had observed his silence. Undersigned counsel declined to join the antics in ignoring rules and ethical provisions and declined to provide information requested by the court, relying on State Bar Rule of Professional Conduct 1.6, which states in pertinent part that a lawyer shall maintain in confidence all information gained in the professional relationship with a client, including information which the client has requested to be held, inviolate of the disclosure of which would be embarrassing or would likely be detrimental to the client, unless the client gives informed consent, except for disclosures that are impliedly authorized in order to carry out the representation, or are required by these rules or other law, or by the order of the court. Now, Brian Steele and, in part Ashley Merchant and Alex Souzer, when they came in later on in the day, they laid out these rules almost word for word. They also laid out a bunch of case law with the relevant citations. Right on the floor, they fired important stuff off to make their argument. And if you were watching the trial today, or you've seen my recap already, when it was time for the ADA Hilton or Chief Deputy DA Love to make their argument last week and today, they don't have case law available. At one point last week, Love even said, "Oh, we disagree. We don't think how he's representing the case law is what it really says, but we're going to defer and argue that to you later." So we get all these rules and the case law, the supporting law, spit out by the defense attorneys in court. But the state seems to struggle every time they have to make a counter argument. They never rely explicitly on something right in front of them. They make some kind of top level zoomed out argument. And today we watched Judge Glanville give the ADA Hilton some time to pull up case law. He was pushing her through it. So I always think it's really interesting the difference in the delivery between the state and the defense counsel in this case, especially this last week. So Comment 5 to Rule 1.6 specifically states, the principle of confidentiality is given effect in two related bodies of the law, the attorney-client privilege, which includes the work product doctrine, in the law of evidence, and the rule of confidentiality established in professional ethics. Now they're bolding this part. The attorney-client privilege applies in judicial and other proceedings in which a lawyer may be called as a witness or otherwise required to produce evidence concerning a client. The rule of client-lawyer confidentiality applies in situations other than those where evidence is sought from the lawyer through compulsion of law. Rule 1.6 applies not merely to matters communicated in confidence by the client, but also to all information gained in the professional relationship, whatever its source. A lawyer may not disclose such information except as authorized or required by the Georgia Rules of Professional Conduct or other law. In other words, the judge did not have discretion on Monday to try to compel Brian Steele, especially in open court, to come out and say who told him something, because that should have been covered by this attorney-client privilege. The judge doesn't have the power, the authority to overrule that. It would only be able to be overridden by the Georgia Rules of Professional Conduct or another law, not the judiciary. The requirement of maintaining confidentiality of information gained in the professional relationship applies to government lawyers who may disagree with the client's policy goals. The court ignored the ethical rules relied upon and continued to demand undersigned counsel to reveal the source of the information, claiming that the way the undersigned counsel obtained that information was somehow, quote, unlawful, and basically baselessly accused undersigned counsel on the record of potentially acquiring the information through eavesdropping. In response to the specious accusations and the impermissible demands of the court, undersigned counsel relied on the ethical mandates of Rule 16 and the Fifth Amendment right to remain silent and declined to provide the source of information which had been proffered. The court is so biased against Brian Steele, undersigned counsel Brian Steele, and or Mr. Williams. The court ignored all laws and pursued contempt penalties to attempt to intimidate undersigned counsel to violate the law and ethics in order to continue to help the prosecution convict Mr. Williams and all others. That's laying it all out. This is scorched earth. You ignored all rules, all laws, because you are so biased and so set on helping the prosecution to convict. The judge, the tribunal, should never be helping to accelerate a verdict in a certain direction. That's not the judge's job. That's not the court's job. It's really not the prosecution's job to pursue a conviction for the sake of a conviction, right? They're supposed to pursue justice. But what Brian Steele is saying here is like fire bombs. like this is heavy. The court issue, and if the judge and Steele didn't have enough beef already, this is it. The court issued a written order of contempt and incarceration for Brian Steele, imposing the maximum sentence of incarceration for 20 days. So they're going to attach a copy of this order of contempt. And we looked through that here, and we know that the Superior Court of Georgia, the Supreme Court, granted the supersedis bond. So no jail time for Brian Steele. He got a win with that one. The Supreme Court of Georgia, there we go, has granted a writ of certiorari to address the appeal of contempt order and has granted undersigned counsel a supersedis bond. The court violated the law by failing its duty to recuse from presiding over this contempt proceeding. In such proceedings where the announcement of punishment is delayed and where the contumacious conduct was directed toward the judge, or where the judge reacted to the contumacious conduct in such a manner as to become involved in the controversy. Put a 1 in the chat if you think the judge is involved in this controversy. Put a 2 if you think he's not involved. The judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted by another judge. And we saw, I believe, Douglas Weinstein, we read his motion to accuse. He cited Schoolcraft as well. Here, the court involved itself in these proceedings by joining the prosecution team and conducting the ex parte meeting that violated Mr. Williams' rights. This created a conflict of interest for the court because its own unethical conduct is questioned and at the heart of the issue. The court then compounded its abuse of power by presiding over the very contempt hearing where its own rules violations prompted the controversy. The court should have recused and allowed the contempt proceedings to be handled by a separate court. And remember, that's strike force. When Ashley Merchant and Alex Souzer and all the other attorneys that weren't allowed to come into the courtroom on behalf of Brian Steele, they all came in. And they wanted to say, like, look, Judge Glanville, this should be heard by another court, a different judge. They told him that. And even though Judge Glanville was just like, nope, I hear you, but I don't hear you. I think at one point he said, nah, I'm good. So he wasn't trying to hear it. Further, the prosecutor sat mute, and permitted the court to attempt to interrogate and intimidate another member of the bar. So they're talking about Kayla Bumpus, who reported a violation of law and also promoted the court's wrongful conduct by asserting that the ex parte meeting was proper. The court denied Mr. Williams and undersigned counsel their due process rights, as undersigned counsel has a right to adequate notice and to be heard, to call witnesses at a hearing, and to be represented by counsel for the entirety of the contempt proceeding, and Mr. Williams had the right to learn of all facts and circumstances of this critical stage of the proceeding that occurred in his absence, ex parte. The court abused its authority by holding undersigned counsel in contempt for refusing to divulge privileged information and for protecting Mr. Williams' constitutional rights to due process, right to a fair tribunal, right to a fair trial, right to be present, and effective assistance of counsel. This court's refusal to acknowledge these rights and protections has created an unfair tribunal based on bias against Mr. Williams and or Brian Steele and favoritism to the prosecutors. And I am glad that they keep attaching in this motion. They keep highlighting that it isn't just the judge that's benefiting or engaging in what's going on, what's being alleged here. The party that's benefiting from what's going on is the prosecution. And not only are they doing nothing to stop it, but they're participating in it actively. And a lot of you guys, I've seen you throughout the last week mention the same thing. Well, what about the DA? What about Love? What about Hilton? Isn't this on them too? Yeah, it is. That might be an ethics issue with the can kicked down the road for a long time, because you know how procedural things go. But they sure are, and I like seeing that added in here. Motion to disqualify, recuse Judge Glanville is timely filed as Uniform Superior Court Rule 25-1 mandates that the time for filing a motion to recuse shall be not later than 5 days after the affiant first learned of the grounds for disqualifications. So, when did Douglas Weinstein file? Was that Wednesday? I think that was Wednesday. The Honorable Supreme Court of Georgia has taught that a motion to recuse is timely filed under USCR 25-1 if it's filed within 5 days after the affiant first learned of the alleged grounds for disqualification, excluding Saturdays and Sundays. There we go. So that's how we get the math. Thus, the motion to disqualify and recuse is timely for the reason it was first learned on Monday, June 10th. So it was Monday, but we don't count Saturday and Sunday, so that gives us 5 days instead of 7. I wonder, they always joke that lawyers are bad at math, but they apparently seem to know how to count those days there. The record also reveals numerous instances during trial when the judge's behavior appears to have been biased against Mr. Williams' counsel and partial in favor of the state. So they cite Millhouse versus State, and they say that contentions that a trial judge's derogatory or prejudicial statements and demeanor will be considered so long as a reviewable record has been completed. One method of creating such a record is to obtain testimony from witnesses who were in the courtroom at the time of the incident in question. The record reveals other instances too, when the trial court wrongly berated counsel in front of the jury. After a number of such incidents, Mr. Williams' counsel, out of the jury's presence, moved for the trial judge's recusal and sought a mistrial on grounds that the judge had shown a lack of objectivity, had displayed bias against Mr. Williams and his counsel, and had assisted the prosecutors in making their case before the jury. Judges have an ethical duty to disqualify themselves from any matter in which they have a personal bias or prejudice concerning a party or an attorney appearing before them. In this regard, a trial judge, quote, shall avoid all impropriety and appearance of impropriety. Do you think, this is going to be a 1, 2, 3 situation. Put a 3 in the chat if you think there's no impropriety, no appearance of impropriety at all. 3 if you think none whatsoever. 2 if you think at least an appearance of impropriety. 1 if you think full out it's impropriety. This trial judge, his conduct has been improper. So 1 for improper, 2 for maybe rising to the level of an appearance but not quite actually improper, and 3 not improper at all. The Code of Judicial Conduct provides that judges shall disqualify themselves in a proceeding in which their impartiality might reasonably be questioned, including but not limited to instances where the judge has a personal bias or prejudice concerning a party or a party's lawyer. Within the context of this requirement, the word should mean shall. So no discretion, guys. If the language said may, that's a little bit open for some subjectivity. When you see words like should or shall in writing like this, there's no leeway, there's no wiggle room. It's must. The Supreme Court is mindful of the extraordinary pressures attending a criminal trial of this magnitude. On the one hand, defense counsel is obligated to vigorously defend his client against all charges brought by the state. Likewise, prosecutors must effectively and ethically present the state's case to a jury. Now, I just want to shout out, we have a lot of ones. We have a 3. We do have, Justin says, by 2, but increasingly approaching 1. A lot of ones, you guys. A lot of ones for full-out impropriety in here. We have Pam, we have another 2. So Pam is with the 2 for the appearance of impropriety. And then shout out to Tyrese, because Tyrese is the one that said 3. So honestly, shout out to you, because I think all perspectives should be welcome. And different perspectives can challenge us to think. So shout out to you for being bold and brave in here, Tyrese. And then Francisco says 9. So I don't know what 9 is, but let me know. 9 is like absolutely everything is flowers, maybe. So at the same time, the trial judge is charged with ensuring that the rules of evidence and procedure are followed, and that the proceedings are both orderly, ethical, and fair. When these several interests come together in the courtroom during trial, disagreements between the bench and bar are to be expected. The instances discussed above and in the Exhibit B, so the joint affidavit, so I think we're getting a new affidavit? That's going to be interesting. I can't wait. However, represent more than mere friction between zealous counsel and a diligent jurist. The judge's conduct, as discussed above and herein, created the impression that he harbored an inclination to be biased against Mr. Williams and his counsel, and partial toward the prosecution. Higher courts need not decide whether such bias and impartiality actually existed, because judges are ethically bound to disqualify themselves whenever their impartiality might be reasonably questioned, including instances where the judge's behavior could indicate that he has a personal bias or prejudice concerning a party or a party's lawyer. As explained, the trial judge in this case participated in ex parte communications with the prosecutor, in which he assisted the state to influence a witness to testify against Mr. Williams. These actions certainly raise reasonable questions concerning the judge's partiality and bias. Because the trial judge's impartiality is reasonably questionable, it is error to deny Mr. Williams' motion for recusal. And do you guys think that's harmless error? Or do you think it's error that comes with harm? To deny this recusal, for Judge Glanville to not recuse himself. At this point in time, too, right? Because there's been other motions filed for Judge Glanville to recuse himself before last week. But today, considering this, contemporaneously, right now, do you think at this point it rises to the issue of being reversible error? That at this point in time, Judge Glanville, if he denies Brian Steele's motion, would that be reversible error? What do you guys think? What's your opinion? Our highest court has set forth at least 3 circumstances in which recusal of a court is necessary on the ground of mere appearance of bias, even in the absence of evidence of actual bias. Mr. Williams does not waive that actual bias has been objectively shown throughout trial as well as on June 10th, but for simplicity, the appearance of bias is also met. 2 of these circumstances arise in the case at bar. So this footnote here says that the 3rd circumstance in which recusal is required on the ground of mere appearance of bias, absent evidence of actual bias, is when a judge has direct, personal, substantial pecuniary interest, so personal, possible financial interest, in reaching a conclusion against a litigant. So that would be like a conflict of interest that might not involve like bias or impropriety, but it could still be a conflict of interest there. Based upon information and belief, does the footnote continue down here? This circumstance is not applicable to the case at bar. So they're not going. That's why they left that in a footnote. First, mere appearance of bias requires the recusal of a judge when the judge becomes embroiled in the controversy with one of the litigants. So they cite Mayberry versus Pennsylvania, Taylor versus Hayes, and they put here that the relationship between the judge and the lawyer was such that due process required recusal of the judge. So I bet if we opened up that case, the judge and the lawyer either had a very favorable or very awful relationship, and whatever the spike in that relationship was, good or bad, it was just a conflict, had to go. So, as shown in Exhibit B, attached here too, the court favors the prosecution and is attempting to sabotage the defense. So they're saying the relationship that the judge has with the prosecution, the attorneys representing the state, that's enough to meet this first way to say recusal should happen. Georgia courts have followed this demand for recusal when the judge becomes embroiled in the controversy. So they're going with Burgar, where it says due process requires that the trial judge cannot be both the prosecutor as well as the judge in our judicial system, and thus must be recused. And from Adams, where the judge reacted to the supposed contumacious conduct in such a manner to become involved in the controversy, the judge may give the attorney notice of specific charges, but the hearing, including the attorney's opportunity to be heard, must be conducted in front of an unbiased, impartial judge. And here we get from Schoolcraft that the trial judge became involved in the controversy as he necessarily applied his impressions from a prior bond hearing in reaching a finding of potential contempt. So, second, due process requires recusal of the judge when the judge takes a role in the accusatory process. So for Murchison, we have that our highest court explained that the Constitution prohibits a scenario where the judge orders a witness to appear before him or her in order for the judge to gather facts to determine whether contempt proceedings should occur, and then the same judge presides over the contempt trial. This is because such a judge-grand jury arrangement caused the judge to become part of the accusatory process, and thus this judge must be recused from further dealings in the case. Here, Judge Glanville has ordered Mr. Copeland's lawyers and others to appear to give information on a contempt proceeding. Same is against the law. So, if really by this point, they're hitting multiple angles on this. So they're not just saying like, look, ex parte rules prohibited this. There's also the issue of you not disclosing something. That's another angle. Well, there's these reasons to recuse yourself if there's bias. But then they're also pointing out, in the midst of this ex parte drama, facts that the judge otherwise didn't already know, that weren't already on the record. The judge put himself square in the middle of somewhere when he came across the new fact. Namely, that Woody was the one who killed Nutt. That's what he says in chambers. That's a new fact that wasn't on the record yet. Especially not from, testimony from Nutt himself. But now the judge is in a position where he's getting access to this fact. And that's a problem. And they're raising this argument here. This is a great filing. So here, importantly, a trial judge has the duty to recuse himself, sua sponte, from any proceeding in which the judge's impartiality might reasonably be questioned, including instances where the judge has a personal bias or prejudice concerning a party. So in other words, with all that's going on, we shouldn't even have to be asking. The judge has the duty to recuse himself, in this case Judge Glanville, sua sponte, without us asking for it. And we're asking, and it's getting denied. So in Marlowe v. State, the phrase impartiality might reasonably be questioned means the existence of an objectively reasonable perception of lack of impartiality by the judge, held by a fair-minded and impartial person based upon objective fact or reasonable inference. From Baptiste v. State, to warrant recusal, the alleged bias must be of such nature and intensity to prevent the complaining party from obtaining a trial uninfluenced by the judge's prejudgment. To warrant disqualification of the trial judge, the affidavit in support of a motion seeking the same must support a charge of a bent of mind that may prevent or impede the impartiality of the judge. And then they cite Estate v. Robertson and say that Mr. Williams meets this mark. Recusal is objectively required. Objectively means no discretion. When the judge serves both as the accuser and the adjudicator in a case. And they cite Williams v. Pennsylvania. In the case here, the court met ex parte with prosecutors and a sworn witness, Copeland, and never intended to reveal that ex parte meeting occurred to Mr. Williams and or his counsel, or to anyone for that matter. The court has become part of the executive branch prosecuting Mr. Williams. Moreover, the prosecutors have abandoned and violated their ethical duties by engaging in this ex parte meeting and sitting silent while the court held undersigned counsel in contempt, and failed to reveal any Brady evidence from the meeting. So thank you again for calling this out in this motion, because it's not just the judge who did something problematic here. The prosecution should have disclosed, we met to discuss this agreement for immunity, and in exchange, we also came across a substantive material, a possible confession, whether it's true or not, right? Because Woody could have just been saying in that meeting, yeah, I killed him. And it could have been not true. He could have just been saying it, but it could have been true. But in any case, it's exculpatory. It's something that the defense should have been made aware of. They have the right to confront this witness on that statement that the prosecution is now aware of. And it's really important that we keep underscoring that it's not just Judge Glanville. And I do want to ask another question, top level here. How often do you think, or how rare do you think it is, rare at all, or very common, anywhere on the spectrum, that the adjudicator, the judge, acts as an accuser? How often, how common do you think it is in other cases, not even inside Fulton County, but anywhere? How rare or common do you think it is for judge and prosecutor to kind of play on the same team in a way that can hurt the defense? Just share your general thoughts on that, because that's a big question here too. The court and prosecutor should not be working together, and in parentheses, guys, they say, but they are teaming up to gain an unlawful advantage over Mr. Williams. Mr. Williams' trial is constitutionally fractured, unfair, and lacks all constitutional, statutory, and ethical safeguards and protections of due process law. The court is biased against the accused and his counsel. No intellectually honest person could... I love language like this. No intellectually honest person could believe that coercing witness Copeland to testify in a star chamber setting meets constitutional muster. This court has failed to follow the lawful path. Instead, the court has unlawfully become the prosecutor, judge, grand jury, biased, partial, potential sentencer, and thus must be removed from this case in toto instancer. So do it now. Only on a motion to disqualify, recuse, it is the duty of the judge to pass only on the legal sufficiency of the facts alleged and to ask whether these facts support a charge of bias or prejudice. Neither the truth of the allegations nor the good faith of the pleader may be questioned, regardless of the judge's personal knowledge to the controversy. The test is whether, assuming the truth of the facts alleged in the attached affidavit, a reasonable person would conclude bias exists on the part of the judge. So what they're saying here is, if you do a prima facie consideration reading this and this affidavit that we're going to get to, we've had a sneak peek at some of the affidavit stuff from Douglas Weinstein's motion to recuse. But when you go through a consideration for a motion to recuse, you're supposed to take the facts alleged, the stuff that's going to be sworn to in this attached affidavit, and consider that if this was accepted as true on its face, would this warrant a recusal? That's the standard of consideration for something like this. So that's what this paragraph here is laying out. This court's conduct raises a strong finding that it has become personally embroiled in the case. It is clear, even to a casual observer, that this court's involvement in this controversy requires this court be disqualified, recused, removed from all, I don't know if I've ever seen triple slashes like that, from all further proceedings in the above referenced case, instanter and another judge, who will duly exercise the powers of the judicial branch with partiality, clarity, and fairness, must be appointed to this case. It is critical to the functioning of our courts that the public believe in the absolute integrity and impartiality of its judges, and judicial recusal serves as a linchpin for the underlying proposition that the court will be fair and impartial. Do you guys believe in the absolute integrity and impartiality of these proceedings? The Georgia Code of Judicial Conduct, Rule 211, mandates that a judge must disqualify himself in any proceeding in which the judge's impartiality must be reasonably questioned or which the judge has a personal bias or prejudice concerning a party or party's lawyer. This motion to disqualify and recuse Judge Glanville, accompanied by the attached affidavit. I need like an explosion, like a firework every time we talk about this affidavit, because it's like there's suspense. It's building. Mandates that Judge Glanville shall immediately cease to act upon any matters involved in the state of Georgia v. Jeffrey Williams, shall immediately determine the timeliness of this motion and legal sufficiency of the attached affidavit, and assuming that any and or all facts alleged in the affidavit to be true, whether recusal would be warranted. If it is found that this motion is timely filed, and we get the parentheses again, guys, which it is, the affidavit is legally sufficient, which it is. Oh my gosh, they're gonna be like ad-libbing at the end of each of these sentences. And that recusal would be authorized if some or all of the facts set forth in the affidavit are true, which it does. Judge Glanville must cease from any further contact with this case, and another judge shall be assigned to hear this motion to disqualify and recuse Judge Glanville. Judge Glanville cannot in any way oppose this motion. And they cite that we've heard Mondi versus Magnolia cited a few times in court. And I do want to emphasize, if you guys are listening and not watching, not reading along, those ad-libs are literally in the filing, written in the filing. It's not me ad-libbing, because I know I do that sometimes. Those ad-libs are part of the written filing, just in case you're listening. The attached joint affidavit clearly set forth the facts and reasons for the belief that bias and or prejudice exists on the part of Judge Glanville. The allegations in the attached affidavit are not just bare conclusions and opinions, but are facts. Here we go. We're getting closer, guys. Georgia Code of Judicial Conduct Rule 211 mandates that Judge Glanville must disqualify or recuse himself from this case. Instanter. Do it now. In the alternative, another judge must be assigned to this case and then order Judge Glanville recused based upon his conduct as stated herein and attached affidavit. These facts can't be ignored. To wit, Judge Glanville's impartiality might reasonably be questioned by an objective observer, and thus Judge Glanville must be disqualified and recused from this case. So, a fair-minded and impartial person would hold a reasonable perception that Judge Glanville lacks impartiality based upon objective facts set forth in this motion and the affidavit. And furthermore, Judge Glanville's potential bias is of such a nature and intensity to prevent Judge Glanville from being uninfluenced by his prejudgments. Judge Glanville's conduct gives fair support to a charge of a bent mind that may prevent or impede the impartiality of justice if Glanville's not disqualified from this case. Further, this indictment must be dismissed. So we're getting to the mistrial. A mistrial granted based upon the court's and prosecution's continued misconduct as shown in Exhibit B, attached here too. A constitutionally required fair trial occurring before a fair tribunal with ethical prosecutors has been violated. This includes, but is not limited to, witness intimidation. So they have United States v. McCloskey, United States v. Linder, United States v. Morrison, United States v. Golding. So they're saying that this is pretty supported in different circuits. So you've got 4th and 3rd cited here. Judge Glanville, lawyers for the state, Love and Hilton, will be called as a witness at trial for the jury to understand this ex parte meeting. They're going to come as witnesses. Whew. You know, I love that. If there's anything out there that is top level entertainment and like live stream trial world, oh, it's when not just attorneys, but now the trial judge is going to be called as a witness. So the jury can understand this ex parte meeting and determine demeanor and credibility. Additionally, Mr. Williams demands all ex parte meetings to be disclosed now in order to properly reveal the full extent of all violations of law and ethics. Again, lawyers for the state, Love and Hilton, and Judge Glanville are necessary witnesses at this hearing and trial to determine the correctness of the motion for mistrial, goaded by conduct of these parties and the judge. Now, do you guys think this was the only ex parte meeting that is unknown to the defense, still not disclosed to the defense? You think this was the one time and they happened to catch it this one time? Do you think it's likely that there were more? Do you think, you're not going to conclude that there were more for certain, but it's worth asking the question now if they did it once? Like, that's crazy stuff to consider. And we're going to get to wherefore. We're going to finish out to this argument. We're going to get to the affidavit. But I do want to thank you so much. It's Rebecca Starr for the $4.99 super chat. You had said that Kayla Bumpus's LinkedIn says that she worked as assistant DA for Fulton County through December 2017. That's interesting because some of this rumblings of the stuff that was going on, this case is digging back 10 years. But the indictment didn't come down. Was the indictment 2020? 2021? It's 2021, right? My brain's scattered. So I'm probably wrong on that. Don't take me absolutely on my trying to recall a date here. But that's really interesting because, you know, I wonder if as a DA she was familiar with some of these underlying acts, underlying things that were prosecuted kind of on their own wing or were kind of just left in stasis, but now are being revived as part of this RICO indictment. That's really interesting. And thanks so much for your support also. And then let's see. So wherefore, based upon the above and the attached affidavit, if Judge Glanville does not immediately recuse from any and all further dealings on this case, the motion must be set down before another judge to determine why Judge Glanville can continue to serve as judge in this case. So you have to argue to us why he should be able to stay. It's not on us to tell you why he should leave, even though we just laid it out in 16 pages. You need to tell us why he shouldn't recuse, why he shouldn't be forced to recuse himself. Further, a mistrial must be granted based upon these judicial and prosecution violations, laws, and ethics. So signed today, we have Brian Steele, Keith Adams. And then Exhibit A is the order of contempt. Guys, I did a video reading this. It's pretty short, but this is really where Judge Glanville said, 20 days on weekends, because you didn't want to tell me who told you about this meeting. But Exhibit B, joint affidavit of Brian Steele and Keith Adams. So shout out to Keith Adams, because we always talk about Brian Steele. We don't get much from Keith Adams, but we've got Keith Adams right here, bold and named. So what do they say, guys? May 2022. Shout out to Drea with the facts here. YSL indictment was May 2022. So joint affidavit of Brian Steele and Keith Adams. We're 18 and suffer no legal disability. We make this joint affidavit based upon our own personal knowledge. And let's, real quick, this affidavit is important because it's sworn. A motion, when you make an argument in a motion, you're not necessarily relaying facts. You're making an argument, and your argument should be based on the relevant facts that prove or support and give you basis for whatever you're arguing. These statements that we're getting bulleted here as 1, 2, 3, 4 in this affidavit is them laying out the facts that support what they just argued in that motion. And again, they're supposed to take these facts at face value to consider if on its face, prima facie, it's enough, if it meets the elements here. So that's why they're separating these things into their own affidavit. So they are counsel for Jeffrey Williams in the above styled case. On Monday, June 10th, 2024, and thereafter, affiants learned the following events, in fact, occurred outside of Mr. Williams' presence and outside of affiants' presence and in a star chamber-like environment. Now we get a big paragraph here. So on Monday, June 10th, undersigned affiants, specifically Brian Steele, asked to have a transcript of whatever conversations were memorialized, and affiants requested the actual recording of anything discussed at this improper in-chambers meeting on said date. This court has obstructed Mr. Williams and below affiants from having an exact image of what was said. This obstruction alone shows that this court is biased and that there's absolutely no privilege in communications in this court's chambers, as this court argued on June 10th, 2024. And there's certainly no attorney-client privilege under any stretch of the imagination, as this court asserted. This obstructionist conduct by the court shows bias, and that this court is intrinsically intertwined in the facts of this case and has prevented Mr. Williams from due process, fair trial, effective assistance of counsel, right to know every material and critical happenings in this case. Further, this court, by its words used on the record when speaking in open court with affiants, as well as the court's silence, as well as lawyer Love's statements in open court, clearly demonstrate that the facts below are true and accurate. The court has also silenced witnesses by improperly issuing a show cause order for contempt. So this is talking about that show cause order for June 25th, that it said something like, it's for Kayla Bumpus and all the other parties that would have been present, right? And it was threatening them with contempt. And it was kind of written improperly. Some of you guys in the comments have pointed that out. At the end of it, it doesn't really say, if you fail to appear, we will hold you in criminal contempt. It was kind of missing some words. But this order included Kayla Bumpus and then some. So that's what they're referring to here. Basically making all witnesses in fear of going to jail if the truth is told about this improper violation of Mr. Williams' constitutional right to be present at every critical stage of this trial fair trial, fair tribunal, effective assistance of counsel, due process under the law, the right to make a record in the case. This court is biased and must be recused. Further, the cross-examination of Mr. Copeland will include facts that occurred at the Star Chamber meeting, which puts, and we've all been, who in here has been waiting for cross-examination of Kenneth Copeland, of Woody? But they're saying here, this is Brian Steele and Keith Adams, that they plan on this cross-examination. What do they plan to bring up? Facts that occurred at this Star Chamber meeting, which puts the credibility of Lawyer Love, Lawyer Hilton, this court in issue. And this court should never be the person who is in charge of the jury when the court's conduct is being questioned based upon the court's lawyers for the state of Georgia's actions. Mr. Williams has been put into a tick box by the misconduct of Lawyer Love, trick box, sorry, Lawyer Hilton, and this court. This court must be recused. And I think I can make this bigger, right? Let me make sure. Is that a little bit better? There we go. This court must be recused, a mistrial declared, barred by double jeopardy based upon prosecutorial misconduct. And that's important, right? So if you've been sitting here and you've been asking, well, if there's a mistrial, are they going to redo the trial again? Well, one, they're going to consider whether or not they actually want to bring the charges again. And if they're determined, it's likely that they would, no matter how much more time it would take or how much more of a mess it could become. But when there's a mistrial granted because of prosecutorial misconduct, double jeopardy. Finito. So this is a huge motion, and it stands out a little bit from the prior motions relating to recusal and also mistrial. If these facts, if this is true, what happens in this affidavit rises to the level of prosecutorial misconduct, a mistrial should be declared and a retrial should be barred through double jeopardy. Mr. Kenneth Copeland, a witness who had been called by the state and sworn on Friday, June 7th, 2024, and who invoked his Fifth Amendment and was held in civil contempt by this court, was brought to Fulton County Courthouse on Monday morning, June 10th. Unbeknownst to affiants, Mr. Williams, or anyone else on the defense side of this case, this court met in its chambers with Mr. Copeland, his counsel, Lawyer Love, and Lawyer Hilton, and at times court reporter Weaver, as well as sheriff deputies and other persons. Deputies may have been instructed to turn off their body cameras. This is may. So this is not an assertion, you guys. They're saying may. So they're not stating this with certainty. It's not a full-fledged allegation. It's being laid down as a possible thing. But can you imagine? Can you imagine if one of the deputies came out and said, right now, they told me to turn off my body camera? Like, holy moly. We think it's bad enough when we see a police officer out on the field do something like that. But if you have a deputy in the courtroom that's, helping out with the tribunal, and then the judge and or the prosecutors tell them to turn off their body cameras for an in-chambers meeting with a sworn witness? It says may, you guys. They're not saying this is absolutely true or we know for a fact. They're saying may. But that would be just, you can't come back from that. There was and is nothing privileged under law about this improper ex parte meeting. This court and the others met with Mr. Copeland for a lengthy period of time. The total ex parte meeting, and they're putting it in quotes, meeting, lasted for more than 1 hour, approximately 2 hours, with the above-named people at the meeting at all or various times. Mr. Copeland continued to make known his assertion that he would not testify even in the face of being held in contempt and ordered to testify under use immunity. This court and lawyer for the Fulton County District Attorney's Office, Love and or Hilton, ignored Mr. Copeland's decision and continued to declare to Mr. Copeland that he would be held in custody until he testifies, or, alternatively, if he persists in refusing to testify, he would be held in custody until not only Mr. Williams' current trial resolves, but until all 26 indicted persons' cases are resolved, whichever is longer. Now, there are other defendants that are not part of the ongoing court proceedings that we're seeing right now. So they were very optimistic at the beginning of this motion, saying that this case would go through the end of 2024. I would say easily through the end of 2025, based on how many witnesses the state has left in their case in chief, let alone who the defense needs to produce. But there's still other defendants that aren't part of this. They're not being tried currently as co-defendants in this ongoing, this bar case, this bar trial. So they're telling Woody, if you don't testify, not only would we hold you in contempt through that, and we'd hold you for even longer. And they're weighing that over his head. And this is the same guy that we watched all last week say that in interrogations with police, and one of his interrogations was over 8 hours. He said it multiple times on the stand, I tell them whatever I wanted to hear, so they would let me go. The state is familiar with these police interviews. They know that Woody will say stuff to be let go. So if 2 days in jail, a weekend in jail isn't enough, we're going to threaten you with that same thing that we know already works with you. It's not a good look. This court was a participant and was present during those admonitions and threats to Mr. Copeland. This is witness intimidation, coercion, and the court has become a member of the prosecution team in assisting the prosecution to induce a material witness to testify. This court, lawyers Hilton and Love, are now all witnesses in this case and will be called by Mr. Williams and or possibly other accused so the jury can determine demeanor and credibility of what occurred at this in-chamber meeting. Please note that the witness list is hereby amended by this joint affidavit to include the court, lawyers Love and Hilton, and all other relevant material persons that have information to share with the jury regarding the conduct, words, and actions at this ex parte communication. This court provided Mr. Copeland with a written copy of the statute on crimes of perjury as well as false swearing. This is no subtle gesture, and one that helped the prosecution team to obtain their mission for Mr. Copeland to change his mind and testify. Lawyer Love made representations to this court in front of Mr. Copeland and his counsel, sheriff deputies, the court reporter, and others that Jonathan Melnick, Esquire, counsel for Mr. Copeland, committed misconduct during his reputation of Mr. Copeland and was not representing the interests of Mr. Copeland. These are knowing misrepresentations by Lawyer Love to this court, and that because that's just disparagement, right? If Love is saying an attorney wasn't doing their job, that he committed misconduct, if he didn't actually, that's disparagement. That's against the rules of professional conduct. And then in parentheses, they say, which Lawyer Love continues to do, which biases this court in the favor of the state and against the accused, their lawyers, and other members of the bar. Further, the court permitting Lawyer Love to speak ill of Mr. Copeland's counsel in front of Mr. Copeland adds to the coercion and witness intimidation. I want to hear what happened in this meeting. Because I can kind of picture, from watching them for so long, I can kind of imagine, like take creative licensing, right? And kind of imagine the things that I can picture Love and Hilton saying and then Woody saying back. But here we're having this scenario, which we might not be, I'm not surprised to hear it, but this wasn't part of Douglas Weinstein's affidavit, right? So this is new in an affidavit for the first time to consider. That in this ex parte meeting, they were sitting there and going, well, Melnick isn't looking out for your best interests. Do this instead. Like, what was going on there? This ex parte discussion violated Mr. Williams' constitutional right pursuant to Article 1, Section 1, Paragraph 7, or 12 of the Georgia Constitution to be present at every material stage of his trial. The court and Lawyer Love and or Hilton speaking with Mr. Copeland, a sworn witness, about his testimony and whether he would change his mind and testify is clearly a critical stage of the proceedings. See, for example, Scudder v. State. As asserted in her motion to recuse, this court filed at 10:40 p.m. on June 14th. Attorney Bumpus. Okay, so on June 14th, was that Thursday? Friday. Okay, June 14th was Friday. Kayla Bumpus, attorney Kayla Bumpus, by her counsel, verified the below facts. These facts are adopted into affiant's affidavit as below. These facts are assertions of attorney Bumpus as statements of her lawyers. See Parrish v. State as follows. So this paragraph, I guess, is going to be from Kayla Bumpus, but that doesn't mean that everything else is going to be from Kayla. Maybe it will be, but at least this paragraph. On Monday, June 10th at approximately 8:30 a.m., Mr. Copeland and his lawyer, attorney Kayla Bumpus, were escorted to the court's chambers and conducted an ex parte meeting regarding whether Mr. Copeland would testify. Those present for the substantive portion of this ex parte meeting were Judge Glanville, Mr. Copeland, attorney Bumpus, lawyers Love and Hilton, members of the court's security staff and deputies, 2 investigators from the Fulton County District Attorney's Office, and the court reporter. I wonder which investigators that was. Because if you guys saw today, if you watched my recap, when Woody's walking in, he's finally brought in to sit down and start testifying, there's a woman that wasn't seated who seems to walk in. It cuts to the camera right at the right moment. They seem to walk in together, and she's looking at him as he's walking by to continue to the witness stand. And I wasn't exactly sure who that was. I thought maybe it was potentially a new counsel, but someone suggested that possibly it could be one of the investigators from the DA's office. So, but I wasn't sure. It was a woman. I did clip it at the end of a video if anyone wants to jump to it. I timestamped it in the last video I uploaded. But I was curious. I didn't recognize her, but maybe someone else would. Maybe at the end of this video, at the end of this reading, I'll pull it up and see if you guys recognize her. So these two investigators are also present, and then the court reporter, Ms. Kristen Weaver. In chambers, this court asked Mr. Copeland whether he was prepared to testify. Mr. Copeland announced that he planned to again invoke his Fifth Amendment privilege on the stand. A conversation among the parties ensued regarding Mr. Copeland's understanding of immunity, how Mr. Copeland thought he may testify if he did not invoke the Fifth, and certain facts of the case. Once Mr. Copeland learned that he could be held indefinitely by the court if he refused to testify, not just 2 years as he initially believed, Mr. Copeland decided he would testify. Mr. Copeland added that his testimony would be a lie. The meeting ended and all parties went to the courtroom. So, it seems like he may have been willing to do the 2 years, to do the duration of this trial. How I'm reading this. Once he learned that it would be longer than these 2 years as initially believed, he was like, come on now. Well, now I'm fine. Get me out of here, but I'm going to lie. So the meeting ends and the parties go to the courtroom. This court never assured that this and its underlined Brady evidence would be revealed to Mr. Williams or his counsel, and Brady evidence includes the fact that this meeting occurred. Instead, this court takes the position that no information about this meeting should ever have been revealed to Mr. Williams, his counsel, or anyone outside of the Star Chamber where the same occurred. This shows that the court has become a member of the prosecution team in an effort to thwart Mr. Williams' constitutional right to a fair trial, and a fair tribunal and due process, and right to be present for each critical stage of the proceedings, right to call witnesses, right to present a defense, right to cross-examine witnesses on critical topics. I think this is undoubtedly critical, including that facts of this case were discussed at the court during the intimidation of the witness. This court must be recused. So we're going to go through it. The court and the prosecution have violated Mr. Williams' rights, and the indictment must be dismissed. The whole thing. After mistrial is declared, and as the court and the state has goaded Mr. Williams into moving for this mistrial recusal of the court. Now again, this would all fall under issues of prosecutorial misconduct. They're intimidating a witness. This would be double jeopardy if a mistrial was granted. On Monday afternoon, June 10th, 2024 at approximately 1 p.m., once affiants made the above known in open court, the court refused to release the transcript of this improper ex parte occurrence, held Mr. Williams' lawyer in contempt of court, ordered Mr. Williams' lawyer to serve the maximum period of time in custody for contempt, that 20 days, all in an attempt to intimidate Mr. Williams and his counsel from understanding and learning about the court's and prosecution's wrongdoing. The court has become a material witness because undersigned counsel has the right for the jury to understand that this court met with Mr. Copeland and the prosecutors in order to convince Mr. Copeland to testify against Mr. Williams. The improper ex parte meeting on June 10th, 2024, with a sworn witness concerning the witness's willingness or non-willingness to testify, and this court giving the witness a copy of the law of perjury and false statements and discussing facts of the case, is unforgivable. This is not an ex parte meeting that the court has had with affiants, ever. We've never done this in chambers, Your Honor. You've never had these meetings with us. It's an issue of fairness, bias. On the very few occasions that affiants have had an ex parte hearing with this court, affiants announced in open court that it needed to speak with the court ex parte. There was no objection by the prosecution, and same occurred. Never was a witness involved in these rare ex parte meetings. Affiants demand to question this court and the above lawyers for the district attorney's office as to how many ex parte meetings they have had. How many? The substance of those meetings, who was present, and the like. Even if just one ex parte meeting occurred, as did on June 10th, 2024, this mandates that the court has forfeited its role as an impartial judge and has become a member of the prosecution team. The court must recuse itself. The court, on at least one occasion, has been fed improper ex parte information about facts of this case and a witness's statements about his refusal to testify. The court met with the witness and spoke with the witness about the witness's will. That's a lot of witnesses. The court met with the witness and spoke with the witness about the witness's willingness or non-willingness to testify, along with the prosecutors, and then held undersigned counsel in contempt when undersigned counsel simply wanted to know why he was not notified of this ex parte, judicially and ethically prohibited meeting. The court has now placed the lawyer for Mr. Copeland and other unknown persons in a position that they need to come before the court on a date certain to give testimony as to who gave the information to affiants concerning this improper June 10th meeting with Mr. Copeland, the prosecutors, and the court. The court has become the executive branch, conducting an investigation as a grand juror prosecutor. This court has lost all impartiality, and Mr. Williams cannot receive a fair trial with this court being present over the proceedings. This court has falsely and wrongly accused affiant, specifically Brian Steele, of being unprofessional and unprepared in front of the jury. Neither claim was close to... Do you guys think that Brian Steele's unprepared? Unprofessional, I feel like that could get into personal opinion territory, and it's fine if you guys want to tell me if you think he is unprofessional or professional. But unprepared, I think that we can lean a little bit more objectively towards. Do you think Brian Steele has demonstrated, he's problematic? It's rising to an extent where he's a problem to the court because he's unprepared. Neither claim was close to the truth or was accurate. The prosecutor sat silent as affiant was wrongly and falsely accused of improper conduct. This court has violated every neutrality, impartiality that it is sworn to undertake. So they cite Johnson v. State here, and the relevant law quoted in the attached motion and adopted and relied upon herein. Even knowing that the court has falsely accused Brian Steele of being unprofessional and unprepared in front of the jury, the court has refused to instruct the jury to disregard the court's improper comments. This clearly shows that the court is biased and impartial against Mr. Williams and or his counsel. Would it be biased and partial? Is that a typo? Yeah. I read through it like it wasn't, but really it should be biased and partial. Or his counsel and in favor of the state, as no fair judge would be correct such a serious misstatement made in front of the jury. The bias of the court is objectively proven. When Mr. Copeland took the witness stand on Friday, June 7th, 2024, he refused to testify and was taken into custody by this court. This court knew, as did the prosecution, that Mr. Copeland would refuse to testify in front of the jury, but the court did not reveal that fact or take any action to stop Mr. Copeland's refusal to testify in front of the jury. Mr. Copeland's refusal to testify in front of the jury prejudiced Mr. Williams a great deal, and the jury should never have heard Mr. Copeland exercise his Fifth Amendment right. This court told the courtroom deputies to prohibit the media from filming Mr. Copeland if and when the court ordered him to be arrested. This direction occurred before Mr. Copeland even took the witness stand on Friday. So they knew. They knew. How to instruct him before he actually does that on the stand? If you don't already know he's going to do that on the stand, but decide to put him on the stand anyway. Now, we talked a lot about Brady in here, but there's also Giglio. I say Giglio. It's another precedential case at the federal level. Brady deals with disclosures of things that could be exculpatory for the defendant. The prosecution has a duty to disclose certain things to the defense in order for them to have a fair trial and a fair, shot at defending themselves. Giglio, if you know that your witness is unreliable or going to lie, and then you put them up on the stand anyway, especially if it rises to the level of possibly suborning perjury, now you've got a different type of violation. You've got a Giglio violation going on. And here, this is bordering on that. This is getting there. So the court told the courtroom deputies to prohibit the media from filming Mr. Copeland when the court ordered him to be arrested. And this direction occurred before Mr. Copeland even took the stand on Friday, June 7th. This court has harmed Mr. Williams by hiding this information from Mr. Williams, having ex parte communications with the deputy and media, and permitting Mr. Copeland to assert his Fifth Amendment right in front of the jury. When the Honorable David Botts brought to the court's attention that he had evidence that the prosecution knew that Mr. Copeland was going to invoke his Fifth Amendment right in front of the jury, this court refused to have a hearing to determine whether the prosecution knew that this witness would invoke his right to remain silent or refuse to testify. And instead, the court had a, quote, problem with Attorney Botts. This is backwards. This court has shown bias against Mr. Williams and his lawyers and in favor of the prosecution. This court must be removed from further dealings on this case. This trial must be mistried based upon goading and improper conduct by the court, and the prosecution and another trial is prohibited and barred by double jeopardy. In sum, the court must be recused and or the trial be declared mistrial based upon the improper judicial and prosecutorial conduct. That includes but is not limited to. The court, lawyers Love and or Hilton are now witnesses because they helped Mr. Copeland change his mind and testify by coercion. The court, ex parte, assisted the prosecution team by convincing Mr. Copeland to change his mind and to testify against Mr. Williams. The court has obstructed justice by ordering any transcript of the June 10, 2024 ex parte meeting not to be produced to affiants to use to particularize this affidavit, as well as to cross-examine Mr. Copeland, the court, the lawyers, before the state, and or others before the jury. Facts of the case were discussed with the court at this impermissible ex parte meeting, and Brady evidence was not revealed to affiants by the court and or the lawyers for the state. And Mr. Williams has questions for Mr. Copeland, this court, lawyers for the state, and others about this improper ex parte meeting, how the same occurred, who discussed the fact that the secret meeting would occur, and the substance of this meeting, so the jury can decide whether the court and the state have colluded against Mr. Williams. I swear that the above is true and accurate. So we've got Brian Steele with a big signature here. And then do we have Keith Adams? Okay, I was going to say, we have Keith Adams too, right? So Keith Adams just overflowed to this other page. But yeah. And then certificate of service, so they're sending it upon the court. They made sure everybody's getting it. So what do you guys think? Holy moly. Right? Because this didn't really go into, you know, Douglas Weinstein kind of laid out bullet point, like rapid fire bullet points. But this takes it a step further. It's evident that things were known. These things aren't just something that Woody surprised them with when he got on the stand last Friday, 2 Fridays ago. This is crazy. This is crazy. And I see Aisha saying here, I just caught it in the corner of my eye. If Kat lets anyone come on video, you should tell her your theory. And then you tag Drea. Drea, if you want a link to come up, I will drop it for you. Let me know. But keep in mind, I gotta go watch the NBA finals. I'm a Heat fan. And I know it's like 4-1 Celtics right now, but you know, no hate. No hate from me, but I'm gonna go watch it, see what happens. But let's sum up that motion on a scale of 1 to 10, 10 being like absolute fire, 1 being absolute trash. Well, how do you rate this motion from Brian Steele and Keith Adams? Hey, what do you think? Oh, Terry, thank you for your super chat. My answer to this, how long before Mr. Steele will get a response? There's a good chance that this will be brought up orally tomorrow in court, and Judge Glanville will go, nope, denied. Oh, can you give us a certificate of immediate appeal? Nope, I'm denying that too. So that's going to have to climb up another leg. But don't forget that Brian Steele already, he has the writ of certiorari granted by the Georgia Supreme Court. So there is some motion in the Supreme Court already that's dealing with the contempt charge. But, you know, you're seeing how quickly they're looking at something like this. And again, that's because there was a threat of, you know, locking someone up, holding them in contempt. But on June 25th, we have possibly other people being threatened to be held in criminal contempt, thrown into jail, if they don't come up and say, hey, here's who told. I'm the one that talked to the attorneys. You know, there could be another incarceration or jailing of another party, potential witness. And that could, again, be another writ of certiorari. So there's a lot. I guarantee you Brian Steele is going to bring this up first thing tomorrow before the witness takes a stand and the jury comes back into the court. But I guarantee you it's going to be denied. So the actual remedy is going to be much further down the road. But who knows? Maybe, you know what? Maybe there's a small chance. Let me know if you guys think there's a small chance that Judge Glanville will walk in tomorrow and be like, you know what? I want out. I'm done. Let me just lay it down. Let me just be done. Let me just be done. And then, all right, Drea, so I am clueless because I haven't been able to pay attention to the chat. But if you need to email anything, it's kat@kattwagner.com. And I think you said something earlier when the stream started that you can't message me on Twitter. So I gotta go, or X, so I gotta go check that, and I'll make sure I follow you back so that way you can. So that sounds good. And geez, it's late. Thank you so much for being here and, you know, being the greatest, the modest with the mostest of all time. I appreciate you so much. And then I'm not going to be able to go through your comments, guys. I'm going to get lost if I try to go through context. But excuse me, I see some fire emojis. So I think that's a 10 for this motion. Lone Wolf, I mean, I agree. Higher court should step in immediately. It's going to need to be, you know, don't forget, guys, Judge Glanville is the chief judge. So this has got to go to the toppest top. And they are demonstrating that they move very quickly, at least as far as the idea of holding an attorney in contempt, right? Maybe they wouldn't move so fast on something like this. Maybe they would. I think there's a lot of suspense here. I mean, I think we're all eager to see what happens. And then, let's see. So we have a 9.3. That's very, very precise. I appreciate the precision with the 9.3. Aaron says, I would say not guilty at this point because nothing they have presented so far is a smoking gun. Now, that's a good devil's advocate question, right? If there was a smoking gun, but there was also egregious prosecutorial misconduct, like absolute guilt, but also absolute prosecutorial misconduct, what happens? Do we say convict and let it be because the conviction's more important? Or do we say, let someone who's 100% without, and again, I'm speaking hypothetically, I'm not speaking about any case in particular. On the flip side, should we say, let someone who is undoubtedly 110% absolutely guilty free because of prosecutorial misconduct, right? That's a whole world of philosophical food for thought there. And then I believe the trial's on tomorrow. Karen Reed trial tomorrow. By the way, I know a lot of people are also watching Karen Reed. There's interesting stuff going on there too. There's not testimony tomorrow from, you know, regular witness, but there is a voir dire from some of the FBI parties. I think 3 FBI expert witnesses. They're doing the voir dire there to see if what they have to say, they're qualified to come say it and can actually get on the stand and give testimony in front of the jury. So I believe Young Thug is live tomorrow, and there's also been a misconception that there's no court in the Karen Reed trial tomorrow, but that's not true. It's just voir dire instead of sworn testimony, so, or in front of a jury. So they should be live tomorrow. 8:30 in the morning. Brian Steele might walk right in there and say, Your Honor, I want to discuss my motion for you to recuse and motion for mistrial. Let's see. Oh, and then Christy. Okay, so Christy's saying that Miss Hyatt, maybe, is this Miss Hilton maybe? Yanked the microphone from Miss Love 3 different times. That was so funny. I only saw this. I didn't notice it because sometimes I'm just listening while I'm doing something else. But the channel Cuff Boys, you guys, they pulled timestamps. And there's this part where Hilton, this was not today, it was Friday, I think. It was either Friday or Thursday. But Love was still sitting right next to Hilton at the prosecutor's desk. And Love kept trying to, like, move the microphone. And then Hilton would be like, no. And she did it 3 times. So whatever Love was about to say, Hilton was like, nope, yank. But Cuff Boys has that timestamp. Super, super funny to see. I want to know what Love wanted to say and what Hilton did not want her to say. And then let's see. Oh yeah, you're right. So let me clarify because I was also talking about Karen Reed. So specifically for YSL, they're doing the motions about these, you know, these videos. Because they're, I think 5 of 6 police videos they want to get in, and the judge allowed the state to bring in 2 videos today. But the remainder, they've got to still hash out some arguments. Can they come in as a whole recording? Do we have to go piece by piece and decide what parts of it can come in? So thank you so much, Brooks Alexander. So the YSL trial tomorrow is going to be those hearings about the videos that we haven't seen so far today. And then Live Live says 10, full on 10 for this motion. And then JP to General 1 says, you know the judge going to deny it. Yeah, I mean, I'd be surprised if he didn't. We have Terry with an 11. And Aisha Kenya. That's a great question. Always good to see you as well. I see you over in TLH chat watching these streams throughout the day. But yeah, hearing that Hilton was crying. I mean, what do you guys think? Do you think that that could be because she has a witness that's being difficult with her and she feels stuck? Do you think she feels stuck in the position that she's in to have to put the witness in a position? You know, maybe he's just crying because other things are going on and it's overwhelming. But either way, it's interesting that you have an ADA crying while all of this is taking place. And then let's see what we've got here. I am heading out soon to go watch this finals game. But let's see. Okay, so that's good to know. So JP to General says court is out, so they told the jury to come back on Thursday. But that's not okay, guys. So if one of these videos is an 8-hour interrogation, one of these interviews that Woody sat for with the police was 8 hours long. So they have to go through that and argue, what are we actually going to show the jury? What are we allowed to show the jury? You know, clean this up. And honestly, the state should want to do that, because if you guys heard the audio quality of the police interviews, if you were a juror, would you want to sit there and listen to a full, unedited, all the irrelevant possible, you know, I imagine it's a lot of Woody delaying and coming up with something to say, things that might not actually be relevant or pertinent. Could just be delays, small talk. Would you want to sit there and listen to 8 hours of terrible quality and irrelevant material if you were a jury? It would be in the state's best interest, in my opinion, to want to prune it down. So if they were being strategic, they should want to sit there and hash this out instead of just saying, let us play the whole thing. So, and Frosty, good to see you. And it says New York. Shout out to New York. Mr. Steele is very prepared. I agree. I mean, he's always pretty pointed when he needs to make an objection. Oh yeah, and then Pam, you're right. I heard that. I saw the masks coming on. Now this is what got me. You find out that there's COVID in the air, and after all of the reasons we've closed court or left early or started late, you find out that someone's sick in the courtroom and that you're going to clean down the whole thing after people leave. But this isn't a situation where you say, out of all of these times we've delayed or called court early, that's not one of them. Because they went until 4 today, right? It looked like they went till 4. Maybe it's how I was catching up with the stream. But I thought that was really interesting, that they have the whole sickness in the trial, and they don't decide to do another delay once again. Otto, it's so good to see you. Otto's one of my favorite people over. I watch a lot of content with Potentially Criminal, a defense attorney that honestly is doing a great job for a lot of things. But if you guys are interested in Young Thug and looking at these motions and what's acceptable, Potentially Criminal Sean, SEAN, might bring it up easier. You know, let me just pull up his channel link. He was discussing the SCOTUS ruling on the bump stocks, and he pulled up like a diagram. It was drawn of different weapons, and YouTube yeeted I guess because it triggered the algorithms having the weaponry. I don't even want to say the word GUN. But it triggered. He was trying to talk about this SCOTUS ruling on bump stocks. I was really excited for it. And it yeeted him because of the content. Even though it was just drawings and diagrams and it wasn't talking about doing anything dangerous, it was relevant to the ruling. But he got yeeted. But some really good stuff on, you know, criminal defense cases. He does a little bit of the entertainment stuff, but I love it over there. And Otto's always in the chat. And Otto yelling gifts because Otto gifted. This is my favorite. This is why I love Otto so much, because every time I gift in Sean's channel, Otto's always so appreciative. Otto, this is awesome. I feel like my world has come 360. That's amazing. If you're replaying and you're in the beginning, you're not even going to hear this till later. But it's so good to see you. And then Drea, yeah, replay gang. Well, and let's close up here. So, no debt. Shout out to having no debt. If you want to be eligible for, on any channel, for a gifted membership, what you're going to do right now, guys, if you've never changed this setting, because I see it happen all the time, there's a money symbol, little dollar bill symbol, next to where you type to say something in the chat. If you click that, you'll see a gift settings option. You have to go in there and you have to say you want to turn on the setting that will allow you to receive gifted memberships. If you do it once, it should apply no matter what channel you're watching at any time. But the gifts are otherwise random. The person gifting them doesn't personally select who they go to. Usually seems to sort by who's active in the chat, but you won't be eligible unless you go turn that setting on. So make sure you turn that on once and for all. Super awesome. And then Otto, so much love for you. Allie, you might be on replay crew too. Hi to you if you're coming in late. And then Susan, thank you so much. I try. I try. And then let's see. Now, CS is asking, that's a good question too. If the defendants are found not guilty, does this all become moot? Yep, because double jeopardy would apply. So they can't just decide with a jury verdict to come out and say, you know, we want to do this for round 2. We think the jury got it wrong. Nope, it would be double jeopardy. So that's a great question. And that's you know, we saw Brian Steele say this should be a motion for mistrial based on prosecutorial misconduct, which would put double jeopardy at play as well. No retrial if a mistrial is declared for prosecutorial misconduct. So, and then Christine Williams says Brian Steele for president 2024. I'm seeing other YouTubers do free Brian Steele t-shirts. I love it. Like when people just get creative and just love it. So I don't know if he'd want to run for president at all, but you know, seems like he at least tries to know some laws, and he's young. I don't know, maybe not a bad idea. But let's Aisha, you might have it turned on. If you are able to receive memberships, you won't see that setting there anymore. I should say that too. If I just directed you to look for this setting, you should see it if you've never turned it on. If you have turned that setting on before on any channel, you won't see that option for that setting anymore. You'd have to go through where you click your profile picture in YouTube and go into like the deep end of your Google account to change those settings after you enable it right at the easy button. So Aisha, you probably have it on already. And then Susan says you've already subscribed to Potentially Criminal. That's awesome. Great chat over there. Really knowledgeable people in the chat over there. I love it over there. But you guys, I don't know if you guys are basketball fans. If you're going to go watch the finals, enjoy it. Thank you so much for tuning in for this motion reading. Again, shout out to Gina. And then Drea was trying to let me know about it as well, even though she couldn't get through. So shout out to Drea for saying, hey, like 911, Brian Steele has filed this motion. It was really awesome to read. And we're going to end here. We've got some the Mario Kart emojis if you're a member. And we're going to end with the I Love Sean. So shout out to Potentially Criminal. Thank you again, Otto. And Michael Sanchez, you're butting in. Hey, Michael Sanchez. You guys all have a good one. Take care. Bye-bye.